Good evening, everyone. We warmly welcome all of you to the YCAF Knowledge Forum for the month of April 2022. We take this opportunity to extend our sincere gratitude to all our members for the continuous support during the past years for our knowledge forums. Also, we look forward to your support in future too. Before moving into today's session, on behalf of the Governing Council of YCAF, I extend a very big thank you for the generous contribution made by all our members around the world for our CSR project. We are very much pleased to inform to our members that we are in the process of purchasing the equipment, and we will be delivering the equipment to the Lady Ridgeway Hospital very soon. Okay, it's another Saturday evening. So it's time to move into our today's session. As you all know, human capital plays a vital role in the business environment. As finance professionals, we should know how the laws pertaining to human capital will have an impact on us and our staff. Today's session will enlighten all our members on the critical aspects of labor law, which all the finance professional will have to be thorough on. So we have a very renowned lawyer speaking to us today, this evening on this topic, Mr. Suren Fernando. Mr. Suren Fernando holds a Bachelor's of Degree from Law from the University of Colombo and also a Master's in Law degree from University of London, specializing in both commercial and corporate law. And also he's an attorney at law in the Supreme Court of Sri Lanka. Mr. Fernando is a regular practitioner in the Supreme Court, Court of Appeal, Civil Appellate High Courts, Commercial High Court, District Courts, and Labor Tribunals, handling a wide range of litigation, including constitutional and administrative law, commercial and corporate law, tax law, and labor law. He has also appeared in several public interest applications, including those challenging and supporting the constitutionality of draft legislations. He has been involved in several law reforms committees and also served as a member of the panel of experts appointed to assist the Constitutional Assembly in drafting a new constitution. Over to you, Mr. Fernando.
Good afternoon, everybody. First of all, thank you to the Young Chartered Accountants Forum for inviting me to speak to you this afternoon. And as you know, the topic is important aspects of labor law for finance professionals, but that's a very wide topic to cover in one afternoon. So the emphasis will be on mainly on certain aspects relating to the termination of employment. I will just share my screen. Is that okay, Radhini? You can see the screen. Okay, I assume you can see the screen. So basically what we will look at this afternoon is the Termination of Employment Special Provisions Act, then the concept of termination for misconduct, or what we call disciplinary termination, then this aspect that you have on inefficiency and incompetence and the position with regard to termination on those grounds, then the question of transfer of employees, the question of termination during probation, and then we will look a little bit at domestic inquiries and also a little bit at the labor tribunal process itself, because that might be helpful in terms of knowing when you are, especially as accountants, maybe going into forensic audits on frauds, etc., what would be required at the labor tribunal stage. And then lastly, we will touch on the question of the payment of gratuity, calculation of gratuity, the ability to forfeit gratuity in certain instances without paying it to employees whose services are terminated, and the powers of the Commission of Labor and the labor tribunals with regard to gratuity related matters. So the Termination of Employment Special Provisions Act was brought about, as some of you all may know, in 1971. When we went into a closed economy, there was a fear that overnight almost, if companies start closing down, large number of people would be left unemployed. And since we don't have a strong social security system, like the dole in the United States, Australia, that lots of people would be financially affected. So having created a situation in which companies might need to close down, rather than take over the burden of looking after those who would be disadvantaged by that system onto the state, if I can say, tried to pass the buck back on to the employers and said, well, you might not have business, but you can sack people as you like. So basically, though that law was brought in that context in 1971, and now, well, it's over 50 years old, we still have it on our statute books. Perhaps somewhat due to the presence of the strong unionization, etc. I'm not saying that it should be repealed, but the question as to whether it should at least be reformed, it's a question, and you will see why. Also, as we discuss it, I'm sure you all will, also the question will arise whether this type of laws would act as an incentive to investors to come in, or whether having these types of laws in their rigid form, I'm not saying repeal in its entirety, but keeping it in this rigid form, whether it will actually be a disincentive to investors. Because social legislation is good, definitely laws must protect the weaker segments of societies between employers generally speaking and employees generally speaking. Employers are in a better bargaining position. So yes, you can have laws which protect employees, but when you talk about social legislation and equity, laws should protect employees, but they must also be reasonable by employers and by society at large. So you may at the end answer the question as to whether this meets that threshold. So section 2 of the Termination of Employment Act, I call it the TEVA for short. The TEVA says that no employer shall terminate the scheduled employment of any workman without either the prior consent in writing by the workman or the permission of the Commission of Labor. Now there is an exception, subsection 4. It's deemed to be terminated if it is terminated for a reason other than punishment imposed by way of disciplinary action. So I'll come to that, back to that in just a moment. And then when you terminate under this act, when you terminate for as a punishment within 48 hours or the expiry of the second day after termination, you must give reasons in writing. So the net effect is that after the coming into force of this act, you can terminate only if it's for disciplinary reasons, because then this act doesn't apply to you. So if it's for disciplinary grounds, fine, you can terminate, and then that will be dealt with later, and we will go into those grounds as well. But if it is not for disciplinary grounds, then either you must get the workman's consent and agree on a golden handshake or whatever, or you must do it with the permission of the commissioner. Now there is a procedure laid down in the act, and how you get permission of the commissioner, a lengthy process, and basically if you can show redundancy, etc., or that you're downscaling and there are genuine reasons which satisfy the commissioner that this downscaling or whatever is warranted, then perhaps you will be allowed to terminate. Even then, if you're allowed to terminate, there is a formula which is gazetted and revised from time to time. Then they will apply that formula to decide the maximum compensation payable as a matter of practice, usually compensation awarded is in fact the maximum. So you might argue, look, I'm a small business. I actually can't afford to sack these 10 people to keep the 10 people either. But if I sack them, I can't pay the maximum because I don't have assets or that type of income to pay it off. But then you will be at the mercy of the commissioner's discretion. Of course, if he wrongly exercises the discretion, you can challenge it in court, but then that's more time and money spent there. So if there's a need for restructuring, then permission has to be obtained through the TEVA procedure. If permission is granted, the question of compensation will arise. That's also determined by the commissioner. So sometimes it may be easier to try and agree with an employee, look, we'll pay you X amount, which is the maximum you'll get under the formula anyway. Or some employers say, look, let's pay more anyway, because otherwise, till this termination process is over, we have to keep paying their salary as well. Plus, we have to spend money on an inquiry. So, let's just pay it. So there is the commercial realities which also will come into play. So that is with regard to non-disciplinary termination, termination under the TEVA. Now, what you would encounter more regularly would be disciplinary termination. And I mean, in the given time of 1 hour, I can't really cover the whole range of disciplinary termination because that's a huge, maybe 1/3 or at least quarter of a degree subject. So we'll look at as much as possible that we can. So what I thought was, we will look very briefly at several of the things which might fall under disciplinary termination and some of the things which don't fall under disciplinary termination. Now, one of the things you often encounter is you might ask, look, do we need to specify what this misconduct is in letters of appointment? Now, there are some things, obviously, if you just refer to termination for misconduct, it's enough. For example, it would obviously cover fraud. It would obviously cover assaulting a superior officer. But there might be some other areas which it is not so obvious. And for that purpose, for example, trade secrets, not dealing with clients, etc., for personal benefit, not sharing trade secrets. So those you might just, so that there is absolutely no doubt and some employee doesn't turn up in a labor tribunal and say, no, but I didn't know that was misconduct, I just discussed these trade secrets with my cousin. How did I know he's going to use it? So that you don't have that situation, it might be better to specify some of these things in contracts or HR manuals, HR policies, which are given to employees and which employees have signed off as being aware. So what are some of these grounds? Now, some of the grounds are absenteeism or chronic absenteeism. You're expected to work according to the letter of appointment, 8:30 to 4:30 or 9 to 5. But you come to work every day at 9:30, 9:45, 10:30. After warnings, it continues. Then that can be considered a form of misconduct. So I've cited one of the cases there. There was a circular in that company which said that if you're guilty of 4 counts of absenteeism, then you can be terminated. So there was also a guideline there, like I discussed earlier. And the courts upheld that and said, yes, that is justified termination. Then the other one is unauthorized absence. So if you're governed by the Shop and Office Act, you might have a statutory entitlement of leave. Otherwise, your contract of employment may provide for it. But you might also say, okay, this is X amount of leave, but it has to be by prior approval because, we need to arrange the company's activities as well. Suddenly you can't just say, hey, next week I'm not coming, I'm off to Bali. Bye. That's not going to cut it. You need prior approval for leave. Obviously, in the case of medical leave, prior approval might be difficult because unless it's a scheduled surgery or something, in which case still they might say, look, you need to inform. And if it is more than 2 days, you need to tender a medical certificate, or there may be some rules like that. So if there is unauthorized absence, even in those situations, that's one thing. The other one is coming late to work, punctuality. And that also not one-off, obviously, but if it's a chronic case of that, despite warnings, etc., that could be construed as misconduct. Then the question of negligence. Now there again, one-off acts of negligence might not get covered. So if there is habitual negligence, or perhaps even one-off negligence which is sufficiently grave, that might amount to misconduct warranting termination. Now, before I just look at those cases very briefly, when you talk about negligence, there is what we call culpability or some responsibility that you take for that, which is attributable to the person whose negligence. That is, he's careless with regard to what he did, or he's wrong in failing to act. So, for example, if your job is a driver and you are driving on the wrong side of the road, or you're driving under the influence of liquor in addition to violating laws, that might be negligence. Or if your job is to make sure that some water pumps are turned off at a particular time each day and you don't do that, then the failure to act can also be negligent, because there is some culpability which attaches to the act or the failure to act. So in the Lever brothers case, there was this individual in charge of machinery and he was supposed to supervise those. He was sleeping at work, and these machines, if they kept running, could have caused damage to other individuals and property. So that was found to be culpable. He was found to be culpable negligence. In the other case that I found, the cited the Bowers case, there was a watcher who was supposed to work until a particular time, and also even thereafter he shouldn't leave until there's a proper handing over. The next watcher didn't turn up, and then he should have actually covered according to the evidence in that case. Now, to compound matters, in that intervening period where he had packed up and gone without handing over, a theft occurred. So his negligence resulted in loss, because if he was there, presumably that may not have happened. So there also the termination was held to be justified. Now, that is negligence. Now, very often we ask the question, we have got this fellow who doesn't do a ball of work, utterly inefficient, can't do anything, can we sack him? Now, sometimes what happens is, you promote a guy who was doing an okay job as a clerk or something, you promote him into a designation for which he is not qualified. And then you complain that hey, he's incompetent, he's inefficient. Well, there I would say the fault is with the person who put him there. In the other scenario, you take a guy, and very often you take on probation, so you have a window in which you can evaluate whether they are suitable or not. You don't make use of the window, and then you say, oh, now we discover that he's inefficient or incompetent. Now here, what you find is that it's not culpable, because it's not that some fault is attaching to him, that he's negligent or that he is not doing what he should because he's lazy or he's refusing to do something that he can, but he just can't. Now, if that is the situation, then there is no culpability, no liability attaches to him there, then that will not be misconduct. So in this St. Anthony's case, what the court said was that inefficiency and incompetence denotes a person's inability to perform the work allotted to him. It is thus not a ground on which termination can be effected by the employer, since it's not punishment imposed by way of disciplinary action, because there is no fault as such. So sometimes there's a very fine line. Where does this incompetence or inefficiency end and negligence begin? Because if you can show, no, he is able to do it, but he is just refusing, then that may be even be insubordination if you're refusing to do, or you're refusing to do, so it's negligent because you're not performing a duty. But if it is not that he can and he's refusing, he just can't, then it is not misconduct. So in that situation, if you want to get rid of the person also, your only remedy, because you can't go sack him and it will be unlawful termination, then you may have to seek again the permission of the commissioner. So we'll also look at some other grounds. So you have insubordination or disobedience. So if there are lawful orders given, so the order should be given by a proper authority, and you refuse to follow them, they are within your scope of work or what your scope can be expanded to. Very often letters of appointment say, these are your responsibilities plus what is allocated to you. So obviously your accountant, if you're asked to go and drive the company bus, then obviously that's not within your scope. That's a malafide instruction. Then that's not obviously something that you can be expected to do. But if there are certain things you can legitimately be expected to do, and you fail to do, that might be covered as misconduct. Threatening superior officers or rudeness to superior officers, abuse of superior officers or even colleagues, all of those might amount to misconduct. Then assault of superiors or even fellow employees, and in certain instances, assault of superiors even outside the place of work might be misconduct, because that chain of command can and the industrial harmony can get affected within the company. So even though it happened outside, it might amount to misconduct warranting termination. Then there have been some, certain cases where people have been in the habit of making false allegations in public about superiors or management, which are harmful to the image of the company or to the workings of the company. So that type of conduct can also be amount to misconduct. And then of course, dishonesty. Now there's a wide range of what dishonesty can be, and we won't go into all of those, but just give me a moment. Yeah, some of them obviously would be theft, misappropriation, manipulating accounting records, perhaps manipulating computer systems, and some forms of dishonesty may be where you steal customer lists and other trade secrets, things like that, or share that information. Those also may amount to dishonesty. So here I would like to pause on the question of dishonesty and fraud, and particularly because I'm addressing accountants, look at, in the case of frauds, what would be the role of accountants with regard to pursuing labor tribunal proceedings, obviously from the side of the employer and not from the side of perpetuating the fraud. So very often when you have complaints or suspicion of fraud, you find, especially where it has been done in a very skillful, if I can use that word, way, manipulating accounting records and computer records, then sometimes we find that the regular, either the internal audits or the external audits, don't detect these frauds because they have been done so skillfully that the records have been manipulated so that your credit and debit entries are reversed using super user passwords. So on the books, you have your credits and your debits, your books are balanced. Sometimes because of the existence of suspense accounts, it makes it easier to perpetuate these frauds. And the random checks done by the audits don't discover. So later when someone complains and says, no, but these entries, I paid this, why is it not showing in your system? How are you asking me to pay? Then sometimes randomly it gets detected, or on suspicion that a fraud happened, when you perform a forensic audit, you find, okay, some sort of manipulation has happened. And then when you go into the computer systems and check from the back end, have these records of this account being changed, then you find, okay, there's a series of changes made. The change was done by the user who had this password. And that's how you start digging out how this fraud happened. Sometimes it may not be as complicated or complex a fraud. Sometimes it might be merely that, there has been a simple fraud, but even that needs to be detected by accountants performing an audit on the available material. So sometimes fraudulent travel claims, etc., which have happened very carefully. Sometimes there are multiple individuals are involved, or sometimes fraudulent approval of loans. So all the documentation is in place on the face of it, but actually there are frauds because either the approval process is not followed, or later on it's detected. And sometimes these arise much later when a person defaults. Then you study the documents carefully, and then you wonder, how did this particular agency issue so many loans to this type of people? And then you find, look, all the guarantors, all the facilities are the same, and they have not checked whether they are persons with suitable creditworthiness. And then accountants might be called upon to go into that and do an audit of the documents, maybe not a proper accounting audit, but audit of the documents. And accountants play a role in all these areas. So that is important, because in the first place, when you have an internal inquiry, if you have one, we'll come to that also. It's not always necessary, but it's useful to come to that. The accountant's information or the investigation will assist the prosecuting officer at a domestic inquiry to lead the proper evidence with regard to the books and how this happened through the accountants, and also to examine the suspect employee as to what has happened, how he approved this, how this password under his control was used to perpetuate this fraud, how he approved such and such loans when all these procedures were not followed. So an audit on the procedures. And in all these situations, accountants play a vital role. And even when it comes to the labor tribunal, and we'll come to that when we look at the labor tribunal, but I'll touch on it now, leading all that evidence before the labor tribunal and explaining to court that these are the procedures, these are the things which have not been followed. This is the reason why in the first instance the loan was approved despite these, and this is why we discovered it only later, because we did this audit of the documents. Or here is a complex financial fraud, and we were able to discover this much later, and we couldn't discover it at the outset through regular audits because this was a concealed fraud, and only through a forensic audit we discovered it. Here is how computer systems have been changed, and this is why we didn't discover it up front, because here you have the credit and debit entry. Then the man has gone and reversed the credit entry and made a debit entry, put a credit entry elsewhere, and balanced off the books, but perpetuated the fraud on the company. And in those situations, someone with the accounting knowledge, someone with the computer skills and whatever, will have to explain how the information is extracted, but how the sequence of events happen would often be explained by an accountant or an auditor, external or internal. So in those situations, a vital role for accountants. Sorry, before, yeah. So in disciplinary termination, another thing that we are often asked is, do we need to have a domestic inquiry before sacking a man? Now, of course, if you are in the public sector governed by the establishments code, then there are rules set out for you, and then certain inquiries are mandated. But in the corporate sector, unless the collective agreement says you have to have one, or your company policy says you have to have one, or in your letter of employment you have agreed on having one, a domestic inquiry is not a must. And the court has recognized that in the St. Andrews Hotel case. Unlike in India, in Sri Lanka, it's not mandatory. But it might serve a useful purpose. Why? Because at the first instance, before you go to the labor tribunal, you know the evidence that you have in your favor, and you know the evidence that the employee, if he chooses to disclose all of it, may have in favor of why he says he's not guilty. So it would be useful for you to evaluate all of that before it comes to termination and facing a labor tribunal case. Also, it might be useful because court cases can take, unfortunately, even in the labor tribunal, a long time. It might be useful to have a inquiry where you gather all your evidence, the parties all sign off on the proceedings and the evidence, so that if, tomorrow one of your witnesses has migrated to Australia, at least you have the record of evidence, and the fact that it was led, I mean, the value of that evidence when that witness is not produced before the labor tribunal, that's another issue. But at least that it was led, the applicant cross-examined on these points. So you have the ability to collect that evidence as well. So while it is not mandatory, it may be useful to lead that evidence and to collect it beforehand. Then we come to the question of transfer of employees. Now, very often again, you may or may not have, you have a transfer clause in your letter of appointment, makes it easier. But sometimes you don't have a transfer clause and you set up a branch somewhere else and you want to transfer an employee. Now the employee says, no, this place is closer to my home. I don't like to go there. Now what's the situation? Now, if it is genuinely required for the purposes of your establishment, for your business efficacy, and it is not for malafide or bad faith intention just to harass the man, you can transfer, but it is genuine transfer, then the law is, and if the Madakombra estate case, where an employee was sought to be transferred between two estates, the court said that to grant, that is the employee's demand, to grant the demand that the management of the estate cannot transfer a Kangani from his division in those circumstances is to interfere with the discretion of the management as to where in the interest of the estate, and it may be of the man himself, the workman should be best employed. Such interference in the management of estates is not in the best interest of their productivity and therefore not in the interest of the country. In the making of a just and equitable order, one must consider not only the interests of the employees, but also the interests of the employers and the wider interests of the country. Because the object of social legislation is to have not only contented employees, but also contented employers. Then in the other case, they said that no doubt the employee is entitled to contest the right of the management to make the transfer. For example, if it was malafide, man is in Negombo, he's doing his work in Colombo, always worked in Colombo. In Colombo, you have a requirement of his particular skills, but because you have had some personal grudge with him, you send him off to Jaffna. When maybe there is a demand there, but there is also a demand here. But the reason you send him is malicious. So even then, no doubt the employee is entitled to contest the right of the management to make the transfer. And the employee is entitled to take necessary steps towards bringing the dispute to adjudication in the manner provided by law. The employee is not entitled, however, to set the employee at defiance by flatly refusing to carry out the order. So basically, sometimes this is called the principle of comply and complain. You can't say, no, I'm not doing it. I'm staying home then. That you can't do. Unless, there may be very, very, very serious circumstances where you transfer, a person to under the supervision of someone with whom he has alleged sexual harassment. Some serious instances like that, employees might say we were justified in staying away. But generally the principle would be comply and complain. That means you comply, you accept the transfer under protest, and then you complain to the Commission of Labor or Labor Tribunal or whatever. But first you comply. That is transfers. The other one that sometimes arises is the question of probation. So now you have probation, basically is a trial period, because the law is stringent as to termination of confirmed employees. You have this trial window, 3 months, 6 months, whatever it is that the letter of appointment says. And that period is intended for you to see whether the person would be suitable for the job role that you have assigned. So management trainee or accounts trainee, you are supposed to evaluate in that period. Now, you can't suddenly at the end of 6 months say, no, we don't like you, your work is not good, get out. That's not what's expected. During this period, you must evaluate And if there are areas where there are shortfalls, document it. Write and say, look, your work is subpar, not good enough. We have been asking you to do this. This is what is expected of you. You're not doing it. Give opportunity for the individual to correct. Then at the end of that period, if you think, okay, he or she has improved, but still not good enough, you may extend the probation. Usually the contracts will say you can extend, but that doesn't mean you can just meaninglessly keep extending just to not confirm. There must be some valid ground. And perhaps after the extension also, if the person is still not up to standard, then you say, look, we have tried you out. We have given you so many warnings, so many chances. You're not correcting yourself. We don't think you fit the job role. So we are unable to confirm you in employment, and your employment is going to cease. But if you stay silent without saying anything, then the courts may infer that by your silence and in the absence of any warnings or letters saying, you know, these are the areas you need to correct, the court may infer that you have in fact confirmed this individual, even though your contract says it must be in writing and you haven't done it, because your own fault, because you have not extended, you have not given warning. So the court may penalize you for that. And that's basically what happened in the state distilleries case. The court set up several tests, and I'll just run through that. The court said that employment to which the Industrial Disputes Act relates is no longer held at pleasure. That's a concept in law. At pleasure means hire and fire. No, that's not what applies even for probation. And the benefit of act, as the definition of workman indicates, accrues to any person who basically is under a contract of employment, including a probationer. Then, secondly, the acceptance of the principle that a labor tribunal has jurisdiction to examine whether termination is mala fide involves the corollary that the employer must disclose his reasons for termination, and you must have some reason. So now we'll come to that in a moment. Now, generally, you can terminate, and you must show that it's justified. In the case of a probationer, you don't have to show that it's justified. You can just say he was inefficient, incompetent. In the probationary period, you can say even those. But the employee can allege mala fides or bad faith. So for confirmed employees, the burden of proving is on the employer. But in probation, the burden of proving is on the employee. He must show that it is in bad faith. So to show that there was some reason, you must have some reason as an employer, and you set that out to the tribunal, and then the tribunal can decide whether the employee's allegation of bad faith is true or not. So then the court said in this case, state distilleries, what is the principal difference between confirmed and probationary employment? In confirmed, the burden is on the employer to justify, and he must do on objective standards, not a subjective standard. He must satisfy the court that a reasonable man would think that, you know, the termination was justified. But in the case of a probationer, the burden of proving that the termination was unjustified is on the employee. Now, the concept of probation, court says, is that it's a period of trial at the end of which the employer must judge the performance of the probationer, and there can't be a proper trial unless you have given him adequate information and instructions as to what is expected of him and as to his shortcomings and how to overcome the shortcomings. You can't say that he failed to reach his expected standard if you have not disclosed what the standard is. So even probationers, be careful, document. This is what is expected of you. These are what you are falling short in. This is where we expect you to improve. And even if you are extending, you document it and say, these are the reasons why. Now, at the end of the probation period, if the employee is genuinely bona fide, in good faith, not satisfied with the work, or he's not quite sure yet, will this guy meet the standard or not, you can either dismiss or extend the probationary period. But if the employer is in fact satisfied with the work, and on objective standards that satisfaction is made out, then you can't dismiss him for some extraneous reason, like you don't like his face. You can't dismiss him for that, saying he's on probation. But then he can go to court and say, look, this is mala fide. They told me this is your job description. They told me this is what is expected of me. Then they said there are some shortcomings in what you're doing, improve. I improved. After that, I have good performance reviews. No other warnings or anything given to me. And suddenly they say, no, we are not confirming you because your work is not good. Why is my work not good? So he can challenge that and say it's mala fide, but the burden will be on him to prove that the absence of bona fides or mala fide. And also, you would have heard in the principle of contra pro forente, or that a clause will be interpreted against he who drafts it. So when you have these type of clauses in contracts of employment, the employer has higher bargaining power, the employer drafts the clauses. So if there's ambiguity as to the clauses or the interpretation, the court will take the side of the party with weaker bargaining power, that is the employee. And in the Brown and Company case, what the court said is that as for the employee, he can't also just come and say mala fide, bad faith. He must establish, because the burden on those cases is on the employee, he must establish by objective standard that the company acted mala fide. Now we will move on. Sorry. To the procedure very quickly, because I mean we can talk about this for a few days probably. So we'll take a bird's eye view at the LT procedure just so that you know what to expect. So the first thing I put there is who should start, or basically who starts leading evidence. Now, if you have an accident case and you go to court and you have sued the offending party and their insurer, you have to start as the plaintiff or the claimant. You must start, because the principle is that he who errs must prove, right? But in the LT, there is a small twist to this. In the LT, they have developed a principle that generally, except in the case of probationers, he who alters the status quo must start. So if you admit that you're the employer and you admit that you terminated and it's not during the probationary period, then the employer must justify the termination. But if you say, no, it's probation period, then you don't have to start. Or you say, no, he's not an employee, he's an independent contractor. He's an outsourced person who's not an employee, not a fixed term contract, not a permanent employee. He's not an employee of any nature. He's some professional providing services once a week. He's not my employee. So I'm not going to start, because then the burden falls on the applicant to show that he's an employee first. Because if he's not an employee, the labor tribunal won't even have jurisdiction. So if you're the employee, you admit termination, it's not probation, then you would start generally, unless there's some ground where you say the court has no jurisdiction. Then you start, because he who alters the status quo must justify the termination. So unlike in the civil courts, where that will happen rarely, in rare instances, in the labor tribunal, very often the respondent, not the claimant or not the plaintiff, not the employee, not the applicant, the respondent has to start and satisfy court. But if it is a case where employment is denied, or you say, no, I didn't sack him, he stopped coming to work, he has vacated post, so I didn't terminate, he has terminated the contract by staying at home, because the contract is to work. If he continuously doesn't come to work, I told him, hey, what are you doing? I need you here. There is no one to do these records. Please turn up. He still didn't come. I said, hello, you have vacated post and you terminate the contract by not coming. So I didn't terminate. Or he's a probationer and I didn't extend for justifiable reason. So he must start and show mala fides. In those situations, the applicant will start. Then what we call the burden of proof. Now there are two things. One is the standard of proof. Now you may have heard in, if you observe, watch, you're a fan of Law and Order, CSI, all these law related programs, the concept of beyond reasonable doubt. Now, if it's a criminal matter and a man is going to lose his liberty or even his life if he's sentenced to death in countries where it's applicable, then the law says there must be a very high standard of proof. It can't be just that on a balance of probability means, you know, you weigh the scales and it's more likely that this happened than this. In civil courts, that's how it happens. But in a criminal matter where you're depriving a person of his life or liberty, then the standard is much higher, beyond reasonable doubt. Without a reasonable doubt, we believe the man did this act, murdered so and so. Beyond reasonable doubt, he did it and his defenses we do not accept. Then, you know, you can sentence him. So in a criminal case, where there are criminal sanctions, the standard is that. But in a civil case, including a labor tribunal, even if you have accused him of fraud, there may be a criminal case for fraud. So to sentence him to jail or impose a fine in that case, the standard may be beyond reasonable doubt. But for the purpose of the LT, which is civil, the standard is balance of probabilities. So that is, having weighed the evidence on both sides, the court must be satisfied this is more likely. Then you can sack the person or say the termination is justified. In the criminal case, it can't be just balance of probability. It must be, we don't even entertain more than a reasonable doubt. There is no reasonable doubt that he did it. That we are sure without a reasonable doubt that he did it. Much higher standard. So in the LT, that is the burden of proof. Then the other issue is this question of confessions. Now in criminal law, because prosecutorial arms or prosecutors have a lot of power and the state has a lot of resources to conduct investigation, generally confessions are frowned upon. And that is because one is you might use undue influence, or sadly, in countries such as ours, and not just me saying it, we have case after case after case of reported cases in our apex courts where the courts have said fundamental rights are violated because they have been tortured. So sometimes torture is used to extract confession. So you do not use those, say, yeah, you confess, so now we convict you based on your own confession. Otherwise, it's very easy. You take the easy way out, torture a man, get him to sign a confession and convict him without doing a proper investigation. So the court frowns upon that. Unfortunately, in some of our, what shall I call them, exceptional legislation like the penal code permits the use of confessions. And sadly, because those laws have permitted the use of confessions, not torture, because they permit the use of confessions, but they have tried to put safeguards saying it has to be a police officer of a particular rank who records a confession. Despite that, there have been numerous allegations that those arrested under those laws have been tortured. And that actually helps no one, because you might genuinely believe that X is the one who did this. So you torture him, get a confession, convict him. And then you find actually many years later, the actual guy who did it has been scot-free all this time and planning other terror. So actually the question as to whether confession should be used at all is something discussed, but anyway, not relevant to you. I just said that as a matter of interest, but what is relevant to you is that standard of no confessions allowed applies to criminal cases. But in civil cases like the labor tribunal, the principle doesn't apply. So at a domestic inquiry, if there is a confession given, that would become admissible in the labor tribunal. And then the burden would shift on the employee to say, no, I didn't give this voluntarily. These fellows all ganged up on me. I was held basically by the HR manager and that accounts fellow and two others, I was locked up in a room with me. They said, we'll break your teeth if you don't give the confession, or they use some other coercion or duress on me. That's why I signed it under duress. Now burden will shift to him to prove that this was not a voluntary confession. But if it is a voluntary confession, it can be used against him. Then, yeah, we go a bit more into the labor tribunal procedure quickly, because I think I'm running out of time and I have more to cover. So the court will then decide who has to start. If you've admitted termination, all of that, you start. And then the applicant gets the opportunity through his lawyers to cross-examine your witnesses. Then if he chooses, he can call witnesses. He himself, he or she might lead evidence. You can cross-examine them. And at the end of the case, the judge will decide which story is more likely, depending on who had to prove. So termination, admitted, confirmed, employee. Did the employee prove? So then the burden is not on the employee. The burden is on the employer to show this happened. Whereas if it's a situation where the employee or so-called employee says, I'm an employee, you say, no, he's not, then the burden is on him, the employee, to show, in fact, he is an employee under a written or unwritten contract. Contracts don't have to be in writing. So the court will, having evaluated all that evidence, decide whether the party which had to prove its case proved it on a balance of probabilities. And within that little aspects, now they bring up a defense or you bring up a defense, then those aspects, the individual burdens on those pieces of evidence might be on another party, although the burden on the whole case is with one party. So let's say you prove your case to satisfaction of court that such an incident happened, and they take up the defense. Okay, I did that, but I did that because a superior officer told me to do it in that way. Then the burden on that aspect, that someone gave him instructions to do it and that's why he did it, on that aspect, the burden might shift to the employee. So all very complicated, but well, I can't help all of it being complicated, because this is, you know, a whole degree course I'm asked to cover in 1 hour. So I'm trying to the best of my abilities to summarize. And then, okay, so then LT can say, no, termination is justified. Sorry, you have been robbing. You have been utterly rude, chronic absentee, drunk at work, or one of those things. So sorry, no remedy for you. Or they say, no, this seems unjust termination. I don't think you, the employer, have proved your case. So what? They can order reinstatement. That means you take the man back and place him in the same position. They can order reinstatement with back wages or wages for the period where he didn't work. Or you might say, no, this guy is in charge of my accounts. I suspect him of fraud. You say, I haven't proved, but even if I haven't proved, can I trust the man with my books because he has access to my systems? So even if the termination is unwarranted, this is not a suitable remedy to say reinstatement. So then the tribunal might say, look, industrial harmony might be affected. This is a fellow who's accused of harassment, of drunkenness, of inciting others. So though it's not proved, putting him back is not suitable. Or a person suspected of other, you know, undesirable conduct like frauds, etc. So though it's not proved, we won't order reinstatement, but because it's not proved, we must give some compensation. Now, labor tribunals have a wide discretion as to the compensation that they can award. But the courts have laid down, so the law doesn't lay down criteria, but the courts have over time developed tests. What must you look at? Maybe his period of service, how much longer he could serve up to his age of retirement, his work quality, whether there have been previous complaints against him, the ability to get this type of a job. Maybe in certain ones, very easy to find other jobs. In certain ones, no. Like that, there are numerous tests which the court will look at. Now, sometimes the courts don't look, they just say, okay, he's been here so many years, so we'll give 2 years as compensation. That's not what's expected. Now, the courts in several landmark cases have developed certain tests. I'll just look at one case. Jayasuriya versus the Sri Lanka State Plantations Corporation, where the Supreme Court said, look, this is, I'm paraphrasing obviously, this is compensation not given like, Christmas bonus, as if the judge is paying out of his own pocket. No, no, no. Compensation means making good the loss which is caused. That is not, you can't say pain of mind, I'm so sad, I'm depressed, loss to my reputation. That you must show in the district court. This is loss of career, loss of employment. That is all the labor tribunal looks at. Of course, they can look at gratuity in certain instances. I'll come to that. But here, loss. So you must do two things. In ordinary contract law, you're expected to mitigate your loss. You can't say, "Ayyo, poor me, I lost my job, I'll stay at home and cry and hope the labor tribunal gives me compensation." No, no, no. You must try and find alternate employment. You must take suitable offers that you receive. So you're the head of accounts. If they ask you to, you are offered a job to drive some chicken delivery vehicle, no, you are not expected to take that. But some suitable employment may not be head of accounts, but something in that line, you earn in 150,000, you're offered a job for 100, you have to take that and mitigate, reduce your loss. So the employer is not there to make good all your loss. You must also try and make good your loss. So the court must ask, did the man try to mitigate his loss? Secondly, they must say, okay, that he tried to mitigate, but he couldn't get a job. Job market is bad. Or he got a job, but he was paid only half of what he got before. So what is the loss? Then the loss is the difference between what you're now earning and what you earned before. So the court must look at a reasonable estimation of loss, not infinity up to, your retirement age, that salary will be paid, not like that. What is reasonable in the circumstances will change, but court must look at all these facts and be fair, and like the case I cited before, fair by the employee, fair by the employer, fair by society at large. So that is on compensation. Now, very quickly, gratuity. Now, gratuity is payable to an employer who employs 15 or more workmen on any day during the preceding 12 months. So on any day, if you had 12 or more, you are liable for gratuity. Then on termination, if you work for 5 years or more, you are entitled to gratuity calculated on the formula, which is half a month per year of service. And if it's a daily paid worker, you calculate X amount of days per year of service as the gratuity. Now, the law also provides that if you have entered into a collective agreement or other forms of agreements that are mentioned there, to pay more favorable gratuity. So there was a company which offered 1 month per year of service. So that's an incentive for employees to stay without going off. Yeah, there's high turnover. You say, no, because when I stay, it's half a month extra for every year I work, calculated at the last drawn salary, so incentive to stay. So you can't keep the man or woman hanging by this incentive, and when they leave, say, no, the access is only half month, no, now we are canceling this. Because once you've held out, that is a contract, because there is an offer. The acceptance is that you've worked because this carrot was offered, then it must be given to you. Now, if those are not paid, then what? Then the Commission of Labor has jurisdiction to inquire into it and make an order under the Gratuity Act. But there is another situation which might be of interest, I think, to accountants, especially since we spoke about fraud and causing losses before. Section 13, not very often used, but it is an important section to know about. Any workman to whom gratuity is payable. So if gratuity is payable and whose services have been terminated for fraud, misappropriation of funds, that's also fraud, not specifically mentioned, willful damage to property, or causing the loss of goods, articles of property or property, shall forfeit the gratuity to the extent of the damage or loss caused. Now, some of these open to interpretation: causing loss of goods, articles of property, Intellectual property, those also might get covered there anyway. Causing, it's open to interpretation, whether it has to be interpreted in the light of the other words or not. Misappropriation, wide concepts. Now, if you have terminated a man for involvement in one of those things, fraud, manipulating computer records, fraudulently approving these loans because 3 or 4 guys were doing this as a chain. So you just say, no, I signed off the documents for there, but you are part of the thing. This is a tool. The employer can say, yes, you earn 500,000 bucks a month. So your gratuity, yes, it should be 3 million maybe, but you have caused loss to me 4 million. So I'm forfeiting your whole gratuity. I'm not paying it. Then what? Then in that situation, the question whether forfeiture has been correctly decided is also a matter which the labor tribunal can look into. Why? Because the Commission of Labor can look into non-payment. That's the standard situation. Termination admitted, salary is there, maybe not much dispute. I say it's so much, you say it's so much. It will be a small inquiry. But here, whether it was forfeiture for reasons of doing one of these might require some judicial inquiry. So when the Payment of Gratuity Act was brought, it amended the Industrial Disputes Act to give that power also to the Labor Tribunal. So I think I have run short of my 1 hour allocation of time. I've tried as to the best of my abilities to cover. I'm sorry, it's not something that you can cover in 1 hour. As I told you, this might be half your course if you are doing a law degree or even a master's degree. I've tried to summarize what I feel is important for your purposes. Try to look at some of the things which might be of interest to you, particularly like collecting evidence and things like that, and forfeiture, how it might work, and documenting those things. So now I will hand back to Radhini, who I think said that she has collected some questions for me from you all. I will try to field them to the best of my abilities.
Thank you, Suren. I think that was a very interesting session. So before moving on to the questions, I would like to remind that a feedback form will be shared at the end of the presentation for all our participants to claim their CPD hours. And also, the recording of this session will be available on the CA Sri Lanka Facebook page. And also, we will be uploading this on the YouTube channel for YCAP. So if you have not subscribed for it, please do so. Okay, let's move on to the questions. Okay, an interesting question, actually. I thought I'll start off with this. What are the remedial actions as employees we have when there is a breach of labor law?
Okay, so that's a wide question because there can be several types of breaches. So for example, if there is a non-payment of gratuity, as I said before, and it's not due to a forfeiture, then you can complain to the Commission of Labor, who is a statutory authority in terms of the Payment of Gratuity Act. If after leaving or during employment, you find that, EPF is being paid on not your full salary or they are not remitting on time, then again, the proper authority is the Commission of Labor. You can complain to him. If there are other conditions of labor or unfair labor practices, you can complain to the commissioner. If there are certain other contractual matters, you may even go to a district court, but that would be rare. But if it is a question of termination of your employment, then if you have been terminated for non-disciplinary reasons, now I said earlier, if it's non-disciplinary, you must get permission or consent. You must get permission in advance from the commissioner. Now, if it is clearly non-disciplinary, you can go and lodge a complaint with the commissioner and say non-disciplinary, they sacked me, you look into it. Now, it's good that you asked this question because I didn't address this earlier. If it is non-disciplinary, however, you will recall that I said the compensation that can be given is subject to the ceiling specified in the formula. So if you are a low level employee, you might feel, okay, that ceiling is high. If I'm not mistaken, now 2.5 million, I can't remember, subject to the formula. So the formula or the 2.5, whichever is high, as I recall, I can't remember the formula ceiling now. But if you are someone earning 250,000 a month, you might think that's only 10 months salary. So I might chance it by going to the LT. Now, if you go to the commissioner, you can also say, look, it's unlawful termination. So declare it unlawful, tell them to pay my back wages and take me back. You can ask that also, but they might counter and say, look, let us terminate, we'll pay something. So you might think, look, I'm earning a lot. So let me go to the labor tribunal, even though it's non-disciplinary, because there my chances of getting something might be higher. So there you must get legal advice. I mean, on all these things, when the situation comes, there is no one size fits all, whether you are the employee or the employer. So based on the peculiar circumstances, based on the contracts involved, based on the wording in HR policies, based on the wording in the letters which have been explained and all other specific facts, you must get legal advice. That is, I mean, non-negotiable. I'm just giving you a general overview. So there you might decide, do I go to LT or to the commissioner for things like that. Whereas if it's disciplinary, you will probably have to go to the labor tribunal. So that's basically in summary. There may be other peculiar circumstances, but generally I think those are the ones.
Okay. Okay. So the next question is, I think when I was listening to your presentation, there were laws which are more favorable to the employees in Sri Lanka. Is there any particular reason for that? Because sometimes when you talk to investors, also foreign investors, one reason they say is, okay, the labor law in Sri Lanka is very stringent, so they're sometimes very reluctant for investments also. So is there any particular reason why the labor law in Sri Lanka is more favorable towards employees?
So I think over time, especially because of the Termination Act, I think that is the single most thing that, if I could pick, which I would say is an issue. So that I suppose the reform should be, I mean, not repeal, but maybe you should say, like you exclude disciplinary termination from the scope of TEVA, inefficiency and incompetence at least should be excluded so that you can sack for that and then justify it in the labor tribunal, of course. And then you can say, look, it's not, the employee can say, it's not my fault. They promoted me. I was just a clerk. They said, you become the accountant. What do I know about account? I just did bookkeeping only. And they made me the accountant and saying inefficient, not my fault, therefore. So you can fight it out there, but perhaps take that out of the scope of TEVA. Make it an exception. Now, as to why, I can answer it in several ways. One is this. One is, as I said, that protectionist mentality that we have had on certain issues has led to these laws. Once we have had some of these laws, now all are not bad. EPF is not bad. ETF is not bad. Gratuity is not bad. Having labor tribunal system is not bad. It's just that sometimes maybe it has to be liberalized a bit. So maybe the problem is that, you feel we can't just hire and fire. Now, I think hire and fire is also not a good thing because you don't have stability or security. So the question is then, if you want to go to the extent of hire and fire, you must build up a very strong social security system, which can, give people enough money to live. And as you know now, the standard, the minimum you need to live, unlike some ministers who think that we can live for a very small amount, because perhaps they eat and drink very little, the rest of us might find it hard to live with that small sum of money. So for the state to provide that, the state will need a huge buffer. Where is the buffer coming from? Tax. Do we have that capacity now? No. So if you have that buffer, anyway, it's going to get passed on to the employer indirectly because you will have to pay higher tax. So there is a trade-off here. So the thing is not to go to hire and fire. I think that's another extreme, but it is to liberalize these perhaps and make it easier for employers in genuine cases to terminate. In fact, I would go further and say that if you change the law in that way, not only employers and investors, it will help the employee also, because who do some of these laws protect? Inefficient and incompetent people. So that means the job opportunities for a skilled, competent, efficient person might be less because you have less investors coming in. Because if you have more opportunities, turnover will be higher. And then employers will be saying, not we want to sack you, hey, please don't go. I'll give you an increment, please stay with me. So actually, we need to look at it in that mindset. And I'm not saying one is correct or not, but definitely some reform is needed. And why doesn't it happen? Because a large percentage of the voter base are employees. So you don't want to annoy them. So that is, in a cynical view, might be that with trade unions and employees. But especially in the situation we find ourselves now, economically, with a pandemic, all of that, now may not be the correct time to bring it, but we need to seriously think whether some reform isn't there some genuine need for reform. And I suppose from the employer's point of view also, there would have to be, some compromise in terms of being more reasonable in terms of minimum wages and things. Guys working in tea plantations, working very hard. If employees are going to fight to keep wages low and all of that, that also may not be reasonable. So I think it calls for everybody, all stakeholders, employees, employers, the private sector, public sector, the trade unions, the chambers, the government, political parties, everybody to be reasonable to come to some sort of agreement on this, because what we have may not actually help anybody.
Okay, I think that was a very comprehensive answer. When we were talking about gratuity, you mentioned that the period of employment should be 5 years. So a question on that. Now you see we have a lot of group of companies, maybe in Sri Lanka or outside Sri Lanka. So for example, if a person is working in a group of company, so he's seconded or rather transferred to the other company. Maybe he was employed under company A and then he is transferred to company B within a short period, maybe within about 2 years. So in that case, will there be a disruption to his gratuity payment, or how will the gratuity payment or rather calculation of gratuity will come about?
Right. So now when you say seconded, what it means really is this: you are my employee, but I'm seconding you to work somewhere else, maybe in my group of companies or whatever. There are also the question as to what transfers are permissible and all will arise. So they are also on the facts of the case. You'll have to look at whether the transfer is possible, whether this is part of the group, whether that was something envisaged, whether it's an entirely independent company, all of that. But assuming that you can, when you transfer him on secondment, it means that the employer remains the same, but he's just working somewhere else. The other situation which can happen is, in a group of companies, you transfer him to the other place, but very often then that place might assume the liabilities of this person in the first place. So the question will be on the facts, on the agreements, but also on the facts, because the agreements might favor the employer and be done in a cunning way, but the court might look at the facts and say we are going beyond that, whether there was a break in service. So did you cease to be this person's employee, and was this a fresh one, or was this a continuation? If it is a continuation, there is no break in employment, whatever you call it. So that will depend on the facts of respective cases, because otherwise sometimes people try to do this shady things of, you keep a person on contract, fixed term contract for 3 years. Then you say, yeah, you take a vacation and come, go to Maldives and come, and your new contract will start next month. So there's a break in service. Now, whether that is genuine or not, court might look into it. Right. So that is, I won't venture a opinion on that, because that will depend on the facts of the case. So if there is a genuine break of opinion or of service, then of course there is no 5 years, because it's 5 years continuous service. The question is, the court has to decide whether there was a break or not. The court will decide on the evidence, and they won't be stuck just with what you say on your paper, pieces of paper.
So cases like this will go to courts, or whether it will go to labor tribunal?
So sorry, when I say court here, I'm talking about the labor tribunal.
Labor tribunal, right?
Technically,
Okay.
you are correct because it's not a court. So it might not go to the labor tribunal. It might go to the commission of labor. Because this is only
Okay.
gratuity. But if there's forfeiture, it might go there. Or if it's less than 15 employees, also the labor tribunal has certain powers. Because statutory due is only if all those conditions are met, including over 15. So if it's less than 15, you can ask the labor tribunal to look at it.
Okay. I think we have had a lot of questions on these EPF and ETF calculations. Now you have a startup company. Is there a minimum requirement or minimum number of employee requirement for a company to register for EPF or ETF?
No. So basically, except for a few exempted ones, almost everything is covered by EPF, right? So the question of it being a startup will not really affect the issue. So even if it's a startup company, if it is a covered employment, as that's a technical term, if it is an industry which is covered, then it will be due.
Okay. When you compute your EPF and ETF, what are the benefits, or rather employment? Does it only restrict to the basic salary and other allowances, or how does that structure work?
Right. So basically, there are very detailed provisions in the EPF Act. So basically, HR should be going through that and looking at that to see that those conditions are fulfilled. But basically, your question probably is like, is it only basic salary? No, it's not. So now, basically, your basic salary is covered. Then, if there is like a cost of living allowance, special allowance, and that type of similar allowance, which is like of a fixed nature, then it is for all intents and purpose. Now, then it's covered. I'm explaining the reason. For all intents and purpose, it's a salary, right? It's something you get every month. Then payments made in respect of holidays, like weekly or public holidays when you work, overtime payments, for the holidays, ones are covered, others are excluded. Then if you're covered by the wages board, of course, some rates are prescribed. So they will have to look into each of those. Then if you are given other fixed allowances for food and things like that, those might be covered. So you would have to look at the specifics and see. But now if you are given a credit card and told entertainment allowance reimbursement up to so much, then that's not covered, because that is you are expected to entertain. So that's a expense incurred on behalf of the company, not really part of your salary. Or if it's some sort of reimbursable thing which is not directly your salary as strictly speaking, then no. So but that again would depend on the way in which those allowances are given. So that would be actually something HR needs to look at on a case-by-case basis and advise.
Okay. Are the employers liable to make EPF, ETF payments during an employee's probation period?
Sorry, I didn't get that.
No, no.
Is a probation also whether it's liable, is it?
Yeah, whether the employer has to remit the EPF, ETF during the probation.
Yes, all employees, it would be payable.
Okay. There is another question. So sometimes what happens is the employee are not terminated. Okay, maybe for some reason they don't terminate the employees, but what they do is they actually transfer them to
Right.
difficult services or difficult areas and force them to resign.
Yeah.
So is it allowed under the regulation or under the law?
Right. So that is what we call constructive termination. So termination not by a letter. So constructive termination is a form of termination and the court can look into it. Now, in your example, someone is transferred. Now, the employer generally has a right of transfer, but you must not reduce the rank. You can't reduce the benefits, and that must be for a legitimate reason. Now, generally speaking, if you're transferred, you must accept the transfer. Now, if you say that I did a case once, I was the general manager, and they, to harass me, asked me to go in the delivery truck delivering chickens. So he said this is constructive termination. So there he refused to accept. But if they said, transfer from Nigambo to Kandy, you might have to at least formally take up the post while filing the case. Now, whether that was mala fide or in bad faith or not, will be something you have to decide in the labor tribunal. Now, here what will happen is, when you file your application, employer will say, I didn't terminate, I transferred. Then what happens? Burden of proof is on you to show that it's a termination. So you must start and satisfy court. So you must show, no, there was no vacancy there, or there was a need here. So when there is a need here, why send me there? Now, not only was these facts there, here there are other things. I went and highlighted that this fellow has been robbing from the till, and he was angry with me. That's why he got me. So then I might be able to circumstantial evidence to show bad faith or malice. So the court will look at all of that and decide whether this is termination or whether this is a transfer. So there, if they say it's a termination, it will be constructive, obviously, because it was not expressly done. And if it is constructive termination, unjustified, then the court will look at compensation as it would otherwise do.
Okay, thank you. Another question. Now, usually our officers are usually from either 8 to 4:30 or 8:30 to 5. So we usually work for about 8 hours. Can an employer in the employment contract say that you have to work about 13 hours? Or is there any restriction or is there any flexibility of that working environment
Okay, so
from the law?
this is actually a contentious area. Now it will depend on multiple things. One is, if you're covered under the Shop and Office Act, certain rules are prescribed. If you're covered under Wages Board, there will be other rules which operate. If you're not covered, then what is prescribed by the employer might operate. Then there is a general presumption that an employer can demand that you perform reasonable overtime. Of course, to people to whom overtime applies, then the higher rates have to be paid for those extra hours. Now, in practice, people of executive grades, it is said that, this is not really not a 9 to 5 job, but there is more involved. So if you can't get the work done in that time, you still need to get it done. That's how an employer would put it. Then the question of overtime becomes a bit tricky, because the law is not very clear on that, because while the law talks about overtime generally, there have been certain circulars issued by the commissioner where they have taken the view that just like in the public service, certain grades are not entitled, in the private sector also, those grades, it may not be that they will not entertain complaints. So that is actually a open question, and very often employers say we are paying higher salaries because you have agreed to this and because we have already factored that into your remuneration. So that would also be tricky. There is no, and there are multiple ways to approach it.
Okay, okay. Okay, when it comes to a resignation, but usually the employment contracts say, okay, depending on the grade of your employment, they either say, okay, 2 months notice or 3 months or maybe 1 month. Certain cases you say 6 months also. So does the law prescribe any particular amount of days or particular time period for giving notice to an employer on
So
resignation?
the law doesn't prescribe. So if your contract has it, it becomes a contractual provision. So then technically they can seek to enforce it if you don't give enough notice by suing you for the equivalent amount of damages in a district court. Whether they will do it or not is another issue. Whether it's worthwhile spending on lawyers' fees over so long period of time to recover 6 months or 3 months or whatever. If they do, of course, we don't mind. But whether it's worthwhile is another question. But generally, the clause might be there more to have a deterrent effect, because also you have to be fair by the employer, or you can't suddenly say, call up, hey boss, from tomorrow I'm not coming, I got another job, bye. Then how is the work going to be handed over? You might have to explain, look, in my, okay, I have done all this work, but in my computer, even the folders that I put are like this. Some other person might not know. You might have to explain, certain procedures that you set in place. So for business efficacy and for smooth functioning, you know, you might need to have a smooth transition, and that's why generally those are put. And also okay, then they might not have someone to fit your role. You might have to get someone from outside. You might have to promote someone. If you promote someone, you might have to get someone to fill their shoes, or if there's no suitable person to promote, you have to get some. So the employer also needs some time, so that must be looked at a little practically. But I mean, if there's unless there is bad blood between the parties, the employee would usually want to give that, and the employer might not, it's 3 months, but you give 6 weeks. They might agree to accept even.
Okay, okay. Okay, so another question on termination. Now, for example, you see a an employer who is not performing up to his standard. For example, we'll take someone like a salesperson who doesn't achieve his targets for maybe about continuously for about 12 to 18 months. He doesn't achieve his target. So now the employer decides to terminate him. So what are the repercussions on the employer in these circumstances? How will that have an impact on him?
You're saying from the perspective of whether the employee can take him to the labor tribunal.
Exactly, exactly.
So right, so now the salesperson, we need to look at multiple things. One is, were the targets that you gave reasonable? Secondly, might be the environment in which he's functioning. So he may have been, selling pen drives in Colombo, in the commercial areas of Colombo. So high demand. Suddenly you transfer him to some village of Anuradhapura or something and ask him to make the same target. So what were those circumstances? You need to look at everything holistically. Then you need to ask the question based on all those facts. Was this due to external forces like the market force, lack of demand, etc., or increase in price, whatever, beyond his control? Then you can't blame him. Or was it because the targets were unreasonable for some other reason? Was it because he was incompetent as a sales guy and actually he never could? He is some driver, because he has met all the agents, you said now you don't have a fellow, so you say, you know the places, you become a sales rep, but he may not have that PR skills or whatever. So is it that? Is it then incompetence, inefficiency, which maybe you're to blame even? So putting him there, or even if you're not to blame, he is not to blame. Then also you can't. Or is it that he is just stubborn and he wants to do things his way, and you have given him instructions, go to the field, visit these people, and he says, "Ayyo bෑ රස්නේ මම කාමරේ AC එක දාගෙන ඉඳලා මම call දීලා බලන්නම්," and he's not doing what he should, then it's culpable. So you need to identify whose fault is the whole thing. And if it's no one's fault also, it's not his fault. No, there must be some fault on his part to terminate him for that. Otherwise, you have to go on the TEVA procedure and see. But there also you have to make sure that it's not your fault anyway. But even to terminate him, it must be his fault. So in your example, I can't answer the question without all the hypothetical facts being known. So if it is his fault that he says, too hot, 38 degrees outside real field, I'm not going to the field, right? You have given me a motorbike, at least you must buy me a car. He's been unreasonable. Then you might say, look, he's not following instructions. This is his job role. He's not even trying. So disobedience. So that depends on all those facts.
So it basically more on circumstantial evidence which the employee should gather and support their side of the story so there is no impact on them, or the fault doesn't fall on the employer.
Yeah,
so that is basically.
Yeah, basically before gathering evidence, you must figure out whose fault it is. So if it's clear that here is a guy who was a driver, some fellow just fill the vacancy by promoting him, he just can't do the job. He's trying, he's doing the best he can, but he can't because he has no PR skills. He can only speak Sinhalese or Tamil, and most of the market is English speaking. So he can't even speak to the customer, or he doesn't have, some people just don't have sales skill. So someone who really wants to buy, no one else will buy. So if it's that, then it's not his fault. But if it's that he's refusing to try, then it's a different story.
Okay, understood, clear. Okay, when you come into employment, there are two types of contracts. One is on this permanent employment contract, or rather permanent employees and contract employees. What is the difference between those two?
Right. So now when you say contract employees, are you talking about employees on a fixed term of contract?
Yes, fixed term.
So now if you talk about fixed permanent employees in employment until the retirement age, unless he's sacked for lawful reasons. Fixed term is, sometimes we say, okay, now my company, we are undertaking some road works. So I have that particular project, Colombo Jaffna Expressway project. Now, obviously, once that is over, people I retain for that, I don't need anymore. So I tell you upfront, you are fixed term for 3 years or 1 year. I have a reason for taking you, or maybe I just need, I have someone on maternity leave, or someone has gone to do a PhD, but they are coming back. So I have a reason why I need someone for a particular period. So I tell you in advance, would you like to come for this period? And I might even pay you more because you don't have job security. For me also it's beneficial, you also it's beneficial. Then that person is an employee for all intents and purposes. You have to pay EPF, ETF, whatever those apply. But the only difference is, by operation of contract, on the expiry of that period, you cease to be an employee. Then you can't go to the labor tribunal. You can go and try, but unless you can show that this is a sham, you will get nothing. The only difference is, like, okay, during the period of the fixed term contract, let's say it's a 3-year contract, you sack the person, then the person can go claim in relief for the balance period of the contract, so they have no entitlement to go on. Now, sometimes what people do is they take someone for a fixed term of 2 years, then they extend for a year and another year and another year, and actually the man is really a permanent employee, but there's a sham of a fixed term contract. So then when it finishes, then of course you can complain that this was a sham. I'm really a permanent employee and these documents were a sham. So that's different. Then the court can, labor tribunal can look into whether it is, genuine or not.
Okay, I think we have one last question. So if there are employees who work on rotation basis, maybe 6 week on and 6 week off. So on such circumstances, how will the gratuity be calculated? What are the factors should be looked at?
Right. So then if this is now this also, it depends again on the facts. Now, if you are actually a permanent employee, you have 5 years completed service, and then the Gratuity Act tells us how you calculate what is completed service. So just give me a moment. So it says completed service. Now, uninterrupted service and includes service which is interrupted by approved leave on any ground and etc. So now if this is a situation where you are actually a permanent employee but you're working like this because the employer has chosen to do it in that way, then it will probably be uninterrupted service. But if after 2 years you go off, take some small contract somewhere, then you come back here, that will be an interruption to service. So you will have to, based on the individual circumstances, check whether that is something which falls within the definition of uninterrupted service. So you will have to have 5 years of that uninterrupted service, because what the section says is 5 completed years, and then completed years is defined to mean uninterrupted service. So you have to fit within that definition.
Okay, I think we have an array of questions, but I think we have come to the end of the session. Any closing remarks from you, Suren?
No, thank you very much for having me. It's interesting to talk to non-lawyers also on these areas, because the issues you all face sometimes are different. So thank you very much for having me this afternoon.
Okay, thank you, Suren, and thank you for all our participants who have joined via Zoom and on Facebook Live. As mentioned before, the recordings will be available on the CA Sri Lanka Facebook page, and also we will be uploading this video on the YCAF YouTube channel. So as we come to the end of the session, so we would like to wish you all a happy weekend and hope to see you all on another knowledge forum. Take care, be safe, bye-bye.